So Peter Button, I only have, Peter, I'm missing a piece of your page, so I'll start with bullet point. I don't even know if it's number 1 or not, but anyway, since 2010, Peter Button is the Vice Secretary General of UPOV. He previously held the role of Technical Director at UPOV. He has vast experience in plant breeding in the private sector, as well as public entities such as British Society of Plant Breeders and the UK Ministry of Agriculture, Fisheries and Food. Peter's been kind enough to be our guest, I think, for I don't know how many AGMs in a row, but let's say many. Never enough, but many. Francesco Mattina, since 2017, Mr. Mattina is the Vice President of CPVO. He presently served as Head of Legal Unit of CPVO, representing CPVO before the EU Court of Justice. He has significant experience as a lawyer in all major areas of IP for the public and private sector. We've had Francesco with us before as well, so it's not a new face. And the oldest face of all, or the most familiar face of all, let me say, is Micha Danziger, illustrious CIOPORA member for years. He's a longtime member of CIOPORA, chairman of the board of Danziger Dan Flower Farm, co-founded by him in 1980. Over 30 years experience in agriculture, floriculture, breeding industries, and a guiding spirit and animating spirit of many CIOPORA meetings. So the format will be we are now, as you see from your agenda, this is basically guaranteeing the future protection for IP protection for plant innovation. Each of our 3 guests will have 5 minutes to give a statement. I'm not saying a position. They can say whether or not it's a position, but to give a statement about their respective areas of practice and expertise. Then we will, that's 15 minutes. Then we will have 15 minutes for discussion among the panel. We can question each other and elaborate on some points that perhaps we didn't have enough time to go deeply enough into in the first 5 minutes. Then the final 15 minutes will be questions from the audience of anyone or everyone up here on the panel. So with that, why don't we start with you, Peter? And do you have a mic? Yes, you have a microphone there.
Thank you very much, Stephen. Good morning, everyone. It's really a great pleasure to see such a large audience. It's really good in UPOV to see CIOPORA growing. We're really pleased to see that. And thank you very much for the invitation to be here again at the CIOPORA AGM and to talk on this very important subject of EDV. So as I have the challenge of being the first speaker, I thought perhaps I could start just by setting the scene. So really the subtitle of this is Back to the Future. So let's go back and think about the UPOV system when it was created. What was the philosophy behind it? Because that relates to the issue of EDV. And when, back in the 1950s, people were talking about the need to encourage plant breeding, one of the decisions was, well, do we need a special system or can we use existing forms of intellectual property protection such as patents? And I think 2 key principles came out of that. First was, I think there were some concerns that the patent system wouldn't really work for plant breeding because maybe what breeders were doing would not meet the criteria for non-obviousness. I think you can debate that, but that was one concern. The idea that basically what you're doing is recombining existing genetic resources. You're not really creating something new. That's as maybe. The other one, though, and I think this has endured through all the history of UPOV, is the breeder's exemption. The need for breeders to have access to all plant genetic resources to make maximum progress for society. This has always been a key driving force within UPOV. So make sure that breeders always have free access even to protected varieties for breeding to make maximum progress. So all was good. The convention came into force 19 1961, or was signed in 1961. But then 30 years later, something happened because they decided to introduce a new concept in the 1991 Act, which was for essentially derived varieties, which essentially goes to the heart of the breeder's exemption. Why did they do that? Well, sometimes when we explain that, it's explained as being, well, it's to balance the situation between patents and plant breeders' rights because of the advent of genetic modification and the possibility to create and patent traits and put these into varieties, and therefore to balance the rights between patents and plant breeders' rights, it's necessary to maybe have some mechanism to limit the breeder's exemption. But if that was the only reason, then when you look at the EDV provision, it would just relate to genetic modification, but it doesn't. As you all know, when it talks about essential derivation, it says one means of possibly creating an EDV is genetic modification, but others, which may, and I emphasize the may, result in an EDV are mutation and backcrossing. So clearly it wasn't just about this idea of balancing rights, and I think I would be rather uncomfortable if that was the only reason. Why was this EDV concept introduced? Well, I think for me it's rather clear they were looking that in order to encourage breeding in a diverse sense, you maybe need to limit the breeder's exemption to make sure that people can't just take an existing variety and then just make one or two small, quick changes and then undermine the investment that's made by breeders that are really trying to do innovative breeding. So it's clear that was a concept behind EDV, to say, okay, there are certain circumstances where we need to restrict the breeder's exemption, because otherwise there isn't going to be an incentive for a broad range of breeding. Every time that someone develops a new variety, there'll be opportunity for people to make small changes, and then, if you like, a lot of the income may be lost. So that was a philosophy, and what we've been doing recently in UPOV in developing the explanatory notes on EDV is to try to clarify, well, what are the circumstances where EDV applies? What is the point to which you limit the breeder's exemption? And also to make as clear as possible what EDV is about. And we've arrived at an explanatory note which has, if you like, drawn a line. It's clarified the concept of EDV, but maybe the discussion is the line in the right place? And I think that's why we're having the discussion here, and why we're keen in UPOV to have the discussion in the seminar in October, to really see, is the line in the right place? Is it going to continue to encourage breeding in a broad way to make sure that society gets maximum benefit from breeding, because breeders are really making the most progress possible? So I would say that's the background. The question is, where do you draw the line, and how do you make sure that as far as possible that line is clear about when does EDV apply and when doesn't it? So I think in our discussion maybe we'll explore where that line is and how do you make sure where the clarity lies. But I thought it might be useful just to put some background, UPOV's philosophy on why this EDV concept was introduced in the first place. Thank you.
So good morning, everyone. It's a pleasure to be here with you today. I thought what should be my contribution, of course, being the Vice President of the CPVO, and also I continue to be in charge of legal matters in the CPVO. I would like to bring the perspective of the granting authority. So CPVO is the agency of the European Union granting titles. So what are the challenges? What are the challenges that we face every day every day when we grant titles, intellectual property rights. In this respect, the other topic of minimum distance between existing varieties and the new one is a topic that we face regularly, believe me, regularly in the office, especially when we have borderline cases. Borderline cases are those that rise up when we receive the results of the technical examination by our testing authorities in the European Union. And we have to take a decision, finally, either to grant or to refuse. Typically, when we receive a positive final DUS report, one would think that we simply grant, we simply follow the opinion of the examination office. Actually, this is not how it works. It may work so for, let's say, clear-cut cases, but there are cases where it is not so, despite a report is positive. So afterwards, I would like to share with you, we had exactly the same discussion last week in the office between legal people and technical people. So since I am the legal people in all the committees of the office, I face the challenge of speaking to technical people in my institution and to try to get them understanding some concepts that today they are better explained by the case law of the European Court of Justice. We also observe, as you know, we don't have that massive case law in this field, not even in the EU by the Court of Justice. But most recently, the complexity of the case that we see rising up in the Board of Appeal, for example, and the Court of Justice, is showing that we have to reflect more deeply on the way the whole process is organized and managed at the end by a granting authority. So the topics deals with validity on one side and scope of the right on the other side. So minimum distance and EDV. We don't deal, of course, with EDV because it's a matter for the scope of the right. We don't have a say on that. But I think there is a link between these concepts that we have to be aware and we have to be very careful in the way we take decisions. Thank you.
Good morning, ladies and gentlemen. It's a great honor for me to speak in front of this great community of breeders. I got the privilege to represent here Danziger Flower Farm and Danziger Innovation, two companies. And I got the privilege to talk in front of you because of cases that we have regarding one of our variety. So my company got a lot of experience in EDV cases, and I feel also that I can talk about EDV because we are dealing with classic breeding and we are dealing also with new breeding technology. And having the experience and the ability to do classic breeding and genome editing, transformation, and so on, I feel that I can talk about EDV with a balanced perspective. And for me, or for my company, it's quite clear that every mutant is an EDV. A mutant is a variety with one single parent, and afterwards it's negotiable between the title holder of the initial variety and the EDV title owner. And we have to try and make very clear laws and rules without loopholes in order that we will be able to profit from the innovation that we are dealing with. Thank you.
Thank you to all three of our panelists, and we'll all take that applause as applause for all three, not just Micha. But I think, you know, on a level, Peter and Francesco, I almost heard Micha say, there's really a business solution here. If you put the line, if you make a firm line that, in Micha's case, that all mutants and all GMO, all new breeding techniques, anything arising from that has a single parent, that's the initial variety, all those are subsumed under the initial variety. And it becomes then a business discussion between the holder of the initial variety and the creator of the second variety, the mutant, shall we say. Is it oversimplifying it to say that? Anybody? I mean, I'm repeating what I hear Micha saying from a business standpoint to say, you know, if you just make a very clear legal statement, the business guys can figure it out.
Okay, thank you. And as I mentioned, I think there are two issues that are important for all of you and all of us as countries implementing the system. One is the clarity of the situation. And I think this is something that would give clarity. I think the discussion in UPOV is going to be in October about, that's clear, but is that in the right place? Because it's back to the breeder's exemption. You know, the very philosophy, the concept behind the UPOV Convention, as opposed to other forms of intellectual property right, is that the tendency, we want to make all genetic resources freely available, including protected varieties for breeders, so that whoever has access to that, we can make the most progress. And if you make it too broad, the EDV concept, then maybe it means that varieties that would have come to the marketplace will not come to the marketplace because maybe the owner of the initial variety would not benefit sufficiently from that. That's the argument that I hear sometimes, that if the EDV concept is too broad, if all mutants are EDV, then maybe there are going to be mutants that are useful that won't make it through because it won't be commercially interesting for the owner of the initial variety. Now, I think what we would like to hear, and I think this is key in our seminar in UPOV where we will be working on this, we really need to hear not the legal arguments, but the business case about what are the decisions that breeders are going to make depending on how we interpret EDV. Because you are the people that have to invest in plant breeding, and is the decision on EDV, or the way in which that's interpreted, going to affect your business decision? And I think that's something we haven't really had in UPOV yet. We've had lots of discussions about what the text might mean and the background and so on. But I think now is the point where we'd like to hear from breeders, well, how does the interpretation of EDV really impact your decisions about what kind of breeding you invest in? I think that would be very, very useful to hear.
I think that the answer is very, very clear. If it will not be that every mutant is an EDV, I'm going to stop, I exaggerate a little bit, to stop classic breeding and do mutation breeding. Very, very simple. And as I mentioned before, we have the capabilities to do it on a simple way, like radiation or treating with chlorhexidine, and we have the abilities to do it with new breeding technology. I think it has to be very, very clear that every mutant is an EDV. That has to be clear. And also, if it will not be like this, maybe the classic breeder will stop breeding. Yeah? So you will get the opposite effect that you want to get. And I think it's very, very important. And I think it should be very clear that if companies with new breeding technology want to make some progress, they shouldn't take my leading variety, they should do it on a free variety. And I can tell you, we at Danziger Innovation, we have nowadays a very, very important project that if it will come through, it will make a revolution in the potato industry. But we took a free variety and we are working on it. Very simple. So that's the answer from the business point of view.
So very, very interesting to hear this discussion from the business point of view. I was reflecting also on the side of the poor judges that have to deal with this concept if they have a case, a rare occasion that they have a case. But I agree with Peter that it's interesting to look into the reasons of the business to understand the background. Eventually, the background of some cases could give us also some tips for reflection when we see what are the difficulties that the judges face when they have to define whether a variety is an EDV or not. And I read with concern and with attention the cases and the background of each case. And especially there have been two recent cases, one from Italy in 2015 and one from Spain in 2016. One was on a rice variety and the second one on tomato variety. And I see opposite conclusions. The Italian court declared the variety EDV and the Spanish court denied that the variety was an EDV. But we have to be very careful because all of these cases are governed by national procedural laws, court national procedural laws and substantive laws on evidence. Evidence is a key point in this kind of litigation. In all the cases, you see the judges struggling on evidence. Evidence on derivation and evidence on the concept of conformity. So maybe we can get inspiration also from the analysis of the case law to try to identify what are the points that create more problems in getting through a case in front of a judge.
I think that because of science is advancing very, very quickly, it will be easier for the judges when they get the reports to know if it's an EDV or not an EDV. Things are changing. We are living in an era that science is changing dramatically every day. And I think that in the past, breeders that were mutant breeders didn't declare that they create mutant. I think this era is going to pass because of better sequencing and phenomics and so on. So I think that first of all, the rules should be clear, not with loopholes, then it will be easier to judge.
Just to reply on this last point, in the Italian case, the judge declared the variety EDV against the opinion of an expert, a technical expert. So the judge appointed a technical expert to hear from him, is it this EDV or not? And according to the case, he said no. But the judge disagreed and said motivation for disagreeing with the finding of the technical scientific expert. So there is not even agreement in the scientific community on these topics. There is no, as I see it from the cases, high unanimity. And in the lack of scientific certainty, I have seen that the judge tend to rely more on, for example, when they have to identify if a characteristic is essential or not, on the official documentation that comes primarily from the DUS testing. If they don't have a solid scientific background on other eventual essential characteristic, they don't want to take arbitrary decisions, and they say, okay, just we rely on the DUS result because the variety was granted PVR, and that's it. And for me, that's a mistake, because you miss other potential grounds which are important.
No comments at the moment. I don't know the cases, so I cannot.
Yes, maybe I could just come back to maybe highlight perhaps where we are now. That in UPOV we have a guidance note which has a certain clarity about it, and there are some debates about what the current guidance note really says, but certainly it can be argued that at the moment what it implies is that it doesn't matter how you do your breeding, but if you create one difference in an essential characteristic, essential broadly meaning something that has some commercial value, you escape the EDV concept. So that's in some ways a clear line. On the other hand, we've heard that there's another clear line that you could apply, which is all mutants, all GM, REDV. And I think the key will be, what are the consequences of those two different approaches? Which is going to produce the best results for society? I think that's really what we need to look at in UPOV, because that's what UPOV is all about, encouraging plant breeding for the benefit of societies. That means maximum progress. And if one approach means, okay, well, breeders are going to say that avenue is not interesting, it's not a sensible business proposition because I'll never be able to get a return, we have to be aware of that, and we need to hear about that. And it really needs to come from those people involved in this business, understanding what their situation is. So I really appreciate your comments, and I think we are going to have a very interesting discussion, and I hope it will be in October an enlightened discussion with people actually involved in breeding to explain what governs their decisions.
So to thank you, I think those are very important clarifying remarks, Peter. You're really you have to balance a lot of things, a lot of interests, and it's the interest of society above all, really, and breeders are working, okay, breeders are business people, they're working for their own business, but ultimately society puts a value on their invention. They either take it up or they ignore it and take something else up. And I think, you know, to elaborate perhaps or take up where Micha was the thread that he was pulling, there's clearly going to be an effect on where the line is drawn that's going to guide the business people as to how they breed. And if the explanatory note prevails as is, and any significant new characteristic in a variety, regardless of how that variety was obtained, becomes a new variety and is not dependent on the initial variety, whether it was a single parent resulting in the new variety, or a combination of two parents. In the short term, that will depress, of course, classical breeding, which has a vast advantage over EDV in that when you combine two different genomes, all kinds of things happen, versus being a very targeted breeding where you're taking an existing genome and making a single or maybe one or two improvements. So the view has to be on two horizons. The short term, what are the short term consequences of where we put the line? And what are the long-term consequences of where we put the line? Because it depends on your time horizon as to what happens when we say, this is it. Could you spend a little time telling our group here what the process will be? So there's a meeting in October, and maybe is that potentially the last meeting, and then, or is that the first of several meetings? How will we finally determine, how will UPOV finally determine where this ends up?
Okay, well, asking me that's quite a tricky one. To see into the future is not my best attribute. But no, to talk about the process in October, I think first of all, it's important to realize we've been discussing this topic for a few years now. It was totally ignored, in effect, in UPOV since about 1991, up until maybe 4 or 5 years ago. But that first round of discussions took place, and we ended up with this explanatory note. I think it's been opened up again because I think UPOV members have heard there are some concerns about where we are today. So open up to really look at this again and see whether we've got it right or whether we need to modify it. So how are we doing that? Well, it's a seminar, and it's under the remit of the Administrative and Legal Committee, which means that we've invited all our members and also observers, breeders, and others to propose issues that they would like to be addressed. So we can make sure that we really understand what people's concerns are instead of imagining for ourselves. And also get some ideas of maybe who the right speakers will be. And then the chair of the Administrative and Legal Committee with the office will then select speakers on the basis of all the information that's been gathered to address the issues that have been raised. Now, that seminar can then feed into the Administrative and Legal Committee to really help it to have its deliberations. I don't think it will be the end of the story in October, but what I think we need to get from October is the facts, the information to inform the CAJ on whether there's a need to revise that explanatory note, and if so, in what way. So it's a key point because we have to decide, do we open it up for revision, and if so, with the aim of what? So really it's, I think it's an essential moment, and we really want to make sure we get the right people to speak, to really present the information and understand what the impacts are going to be. And I think that in the past we haven't really got to. We've tried to get to it, but we've never really got people to talk about the impact. So I really hope Micha and others will be able to ensure that we get the right people there so that everyone is clear. If you go this way, these are likely to be the consequences. If you go that way, these are likely to be the consequences.
Thank you. I think now we have a chance to open the questions to the audience. There's something I understand that's called a flying microphone. Right now is landed in Anna's hands. So you raise your hand and the microphone flies to you somehow.
Okay, we have a lot of bottles, so I will come to you. Just show me your hand if you want to say something. I threw it a little bit.
Okay, yeah. I have two things. One, you could say a remark. We talk quite a lot about the explanatory notes. For me, it's a very difficult word. Mr. Button, you're not talking with breeders of food crops with very innovative mutations. We are flower breeders, pot plant breeders, fruit breeders, and often we are confronted with very, you could say, simple mutants. When I look to the flowers, we have color mutants quite a lot. I think when we are talking about chrysanthemums, for instance, I guess that maybe 50 to 60, maybe even 70% are color mutants. And if your explanation of the explanatory notes really comes into force, these chrysanthemum breeders have very, very big problems. I hope you realize that. But in October we can discuss that later. I have a question for Mr. Francesco. First, I want to say that personally I'm very satisfied about the CPVO. It works, in my opinion, quite well, very good people working over there. But one thing I miss a little bit, but maybe you say it's not my responsibility. As a breeder, we are often confronted, sometimes, often depends a little bit on the crop, with illegal propagation. And then it's very hard to prove and to go after it. Do you see it as a responsibility of the CPVO to help the breeders in these cases? Or do you say, it's not my problem, I do the DOS test and I say you have PBR right, yes or no, and illegal propagation enforcement, it's not my problem?
So, Francesco, the basic question, if I can recap for Peter, is in cases of infringement, to what extent can he rely on the good offices of CPVO to not to make a determination? Well, not to make a juridical decision, of course, but to help sort out the problems of is it or isn't it?
Well, there is a principle of cooperation between the administration and the judiciaries, which is in the basic regulation, so in our Finding Act. So on a general level, I may say that from our, let's say, field of practice, which is granting the titles, indeed we can support a judiciary in determining key findings for a case. But that would be all our role. If imagine that the court is calling the CPVO, and sometimes it happened that we receive a request for information. Just last week, for example, I received a request on a case that is pending before court, and the court want to know where we are with the declaration of invalidity of this title, because it's our exclusive jurisdiction to say whether a title is valid or not. So I'm following up on that request and trying to provide as much as comprehensive information to the court on that topic. I don't see, honestly, other way we may be more involved in judiciary work in this kind of litigations outside of providing all the support and the information we have, as I said, on the basis of a principle of cooperation, which is there. But I don't see it very much used, honestly. In 7 years of working in the CPVO, I have received a bundle of requests from courts, both criminal courts and civil courts, not so much. Not even, I could imagine, for example, that the judge might call the CPVO staff, why not, in a court hearing, eventually to give an opinion, not more than that. Why not? I have seen it done for other IP rights when I was practicing a litigation in IP rights, but I didn't see in PVR, happening in PVR. So I see a possibility, but of course with some limitations. We are not responsible for infringement, but we would like to be supportive, of course.
Thank you. Other questions from the audience?
Thank you very much. I'm Mattina, Secretary General of CIOPORA. I had a lot of questions for all of the panelists. Let me start with Francesco. There's one discussion in the industry and also in UPOV and in the members of UPOV. Who is responsible for declaring variety to be EDV or not? Would the CPVO be happy to have this role, or would they say, I'm happy that we don't do it? And then on top of it, on the basis of the current rules.
No, I speak
Happy that we don't do it. And then on top of it, on the basis of the current rules.
No. I speak in my personal capacity here, not expressing official opinions, but the answer would be no. This, as it is now, as I see it, is regarding the scope of the right, as we said and we heard, the limitation of the breeder exemption. We are not involved in this. As you may know, we only record if a variety is an EDV, if there is agreement between the initial and the subsequent breeder, or if there is a judgment or an administrative decision, which is final. But we don't enter into the determination if it is EDV or not. And the second part of the question was if I would be happy to do so in light of the current principles.
That was an additional one. I think the
Current
first one
criteria.
answered already.
I would also reply no to the second one.
If I may, I would ask one question to Micha, which then leads to one statement for Peter. Peter started.
One, please, easy question.
It's an easy one. For you, it's a very easy one because you're a smart guy.
Thank you.
No, Pete, in his initial statement, Peter related the EDV concept to plagiarism. So EDV was established because we wanted to cover varieties which are very similar to the initial variety. They should be falling under the EDV concept. You are a breeder, and you are breeding in chrysanthemum, and Peter already mentioned color mutations, and you are doing new breeding techniques. Do the varieties which you result from new breeding techniques, for example, would you consider them plagiarism? Or is that an innovation, what you do when you do something with new breeding techniques?
I think I said it loud and clear. I think if it's a mutant, it's an EDV. It can be a very, very important EDV that contributes a lot to the variety. Let's say if you bring resistance, yeah? It has very high value for the grower, for society. But it's an EDV, and then you have to find a business model how each party earns in relativeness to his contribution to the new variety. That's also in the patent law. Yeah? Why we should be different than patents? If I take a variety of Selecta, of Syngenta, and I'm doing genome editing on it, we will discuss afterwards how each one of us have to earn money. And at the end of the day, I think one very important thing is that only companies that make money out of their innovation can continue and invest and make progress. Without the money today, you cannot progress. And cost of new breeding techniques and all the costs are going up. Competition is so tough that the margins are very, very small. And if we'll have also to fight for our rights, it's too expensive. I know how much it costs when you have debates and you have to go to court. You can do it only if you have real star varieties. Otherwise, in the ornamental business, there is not enough money to go to court cases to protect your IP.
Thank you, Micha. That answered my question. I understood from you that many of the varieties which you develop by the way of new breeding techniques, or almost all of them, include an innovative step, so would not be called plagiarism at all.
No, it will not. Let's say a variety, a new variety, a mutant that deserves something will not be plagiarism, yeah?
Exactly.
If it's plagiarism, you don't have to get nothing.
Yeah.
I say that if you do mutation breeding, and never mind how, and you read something that is valuable, then let's talk about it.
Okay, my last statement, and this is for Peter, and I think it makes the bridge to the next point, the next panel discussion point. When you mentioned plagiarism, I know this is discussed in UPOV and the members and also in breeders. What is the aim of EDV? You mentioned plagiarism and very small differences between the initial variety and the EDV, so we call it plagiarism. If EDV is to cover plagiarism, why the concept of not clearly distinguishable varieties has been involved in the 1991 concept? This is the varieties which don't receive protection because they are not distinct enough to get protection. I think, and that is, maybe you think about it, you will make the next initial statement probably on minimum distance. I think that is very much related. So our perspective is, if a variety is so similar to an original variety that it even doesn't receive protection or should not receive protection, then we don't speak about EDV at all. EDV is varieties which are different, which receive protection, which enjoy protection. And then we speak, and the next question is it an EDV, yes or no? But to mix plagiarism with EDV, of course, has the great potential to limit this concept very much, which is dangerous, as we heard from Micha. Thank you.
Thank you, Edgar. Well, you said it was a statement, so therefore not a question, but I would just like to clarify, I did not use the word plagiarism, precisely because it will cause confusion. And I think it was very clear what I was saying, I was not trying to relate this to the concept of plagiarism, and I'm not sure it's an easy thing to do in the concept of plant breeding. So just to be clear, before we go on to the next topic, whenever that might be, but just for the record, because I know this is being recorded. Thank you.
Okay, well, okay, one last.
Yes, I've got a question. I'm Andrew McKenzie, Business Development Manager at Plant and Food Research. Question for Peter Button, and depending on his answer, I guess I could expand a little on the business impacts of that. But my question arises because on reading the explanatory note on EDVs from UPOV, I'm more confused than I was before. So, simple question for me is, would UPOV consider now a simple mutation of, let's say, an apple mutation that might be a full red mutation from a bicoloured apple, or maybe in flowers a red flower mutation from a white one that may be naturally or artificially induced? Would either of those be considered now to be an EDV?
Okay, thank you. Well, as I mentioned, there is still some discussion about what the explanatory note means, but I think if you, there were a lot of discussions leading up to the new explanatory note, and I think one of the things that was quite influential is the fact that there is one UPOV member, at least, in which the PVP office makes a determination on whether a variety is essentially derived or not, and that is Australia. And in Australia, they have this very clear interpretation, and I think this was quite influential for all UPOV members, which is that, well, if a variety differs by one important characteristic, meaning something that has commercial value, it's no longer EDV. And that gives them a clear position. So that gives you an indication of what lay behind the explanatory note. Now, and I think the discussion in UPOV is now, well, is that the right place to be? And I think to know whether that's the right place to be, we need to hear, and we've heard from Micha and also from Peter, that this may not be the right place to be from your perspective in terms of where you're going with plant breeding. But the thing is, a lot of you, this is perhaps very obvious to all of you, but please be aware it is not at all obvious to the people that maybe come to Geneva. And we haven't necessarily heard these clear points and the consequences in Geneva. And certainly it wasn't very clear, the consequences in the discussions leading up to the explanatory note. So please make sure that your voice is heard about what the impact is going to be in terms of the direction that you go with your breeding. And the acid test is benefits for society, and to some extent, you know, you can imagine a situation where breeders are quite happy because they have their germplasm pools, and they work within those, and you don't make so much progress overall as a society. But breeders are happy, you know, they get their new varieties, but the increase or the incremental advances are not as big as if they were, you know, if they had the protection that enabled them to to be more broad in their crossing programs. And also to pick up on Peter's point, I think the other interesting development is certainly in ornamentals and fruit. You face a lot of situations where there are a lot of color mutants, a lot of mutations on fruits, apples, for example, that come about quite easily. Whereas in the agricultural sector, this was not such an issue. But as Micha's pointing out, it's becoming an issue. Because now with new plant breeding techniques, it's going to be a lot easier to get the same kind of scenario. So I think now there's a bit of a leveling of the playing field between what the issues are for agriculture, horticulture, ornamentals, and so on. So I think that's another issue that will perhaps come into play in the discussions in October. But we want to hear you and hear exactly the kind of things that you're saying here in Geneva, and also with the information and the explanations that go with it. Then I think I'm reasonably confident that we'll end up going in a good direction.
Great. Well, you know, first, thank you to the panelists. We unfortunately don't have more time for questions on this topic. There are, well, since we solved it, essentially, we're going to move on to minimum distance, I think. And